My name is Jeffrey Liesemer. I'm a member, which is synonymous with shareholder of Caplin Drysdale, chartered in Washington, D.C. The focus of my practice is commercial litigation and business reorganizations and restructurings, which includes international insolvencies and representing creditors and creditors' rights. I've been in this field of bankruptcy and reorganizations for about 25 years. In addition to our commercial litigation and insolvency practice, we have practices in tax controversy, international tax, nonprofit work. Our clients run the gamut from large corporations to middle market companies to also individuals. And the philosophy of our firm is for each of our practice groups to operate as boutiques. And that allows us to streamline our costs and pass on to savings to the clients at competitive legal rates, while at the same time providing quality legal service.
My name is Kyle Broadhurst. I'm a partner at Broadhurst LLC in the Cayman Islands. We're a litigation boutique. We have 6 attorneys, and I've been practicing in Cayman since 2001, so for about 16 years now. My focus is on insolvency, but also commercial disputes, shareholder disputes, and so on and so forth. We have 4 litigators at the firm and also 2 corporate providers as well, so we're sort of a full-service shop.
Well, we are part of the insolvency group of IR Global, and we collaborated on a virtual series that dealt with following the money. That's what its title was. It was about asset tracing and recovery, and that was a good experience. And yeah, we've been collaborating and working together on other projects here at the conference.
Absolutely.
Yes. Basically, what we're talking about here is Chapter 7 of the Bankruptcy Code, which deals with straight liquidations. You have a trustee that takes over the debtor's assets and translates them into cash and distributes them to creditors. We also have Chapter 11, which deals with reorganizations of a debtor. And in that particular instance, especially with companies, you have the debtor's management basically taking over the case and negotiating with all the creditor constituencies to work out a plan of reorganization that is voted on by the creditors and approved by the court. Chapter 11 is a comprehensive type of bankruptcy remedy because the debtor can assume or reject executory contracts and can borrow obtain financing post-reorganization, post-bankruptcy. And it also allows certain flexibility with respect to allowing the debtor to craft creditor classes in the plan, and that allows it to obtain voting that can allow it to cram down on dissenting creditors under certain circumstances. And my sense is that it's more of a little comprehensive, and with respect to the insolvency regime in the Cayman Islands, it can be more targeted or rifle shot.
Yeah, well, yeah. So, just going through what we have in the Cayman Islands first of all. So we have when we say bankruptcy in the Cayman Islands, we're normally referring to personal bankruptcy, and we have a very old law from the 1880s, which is very seldomly used. I think there's only been one debtor's petition ever, which we did, but it was very specific circumstances. So what we're really talking about here is corporate insolvency, though. And we're really looking at 2 different procedures in the Cayman Islands. You have voluntary liquidations and you have court-supervised liquidations or involuntary liquidations. Now, voluntary liquidation is going to happen in a number of different events, but the key to it is it needs to be a solvent entity. So it's an insolvent entity. The liquidation, even if it starts as a voluntary liquidation, is going to have to be put under court supervision. Once you're dealing with involuntary liquidations, then I think this is getting closer to what you'd see as a Chapter 11, I think. But again, there's a number of different differences. And so I think you were talking about the concept of arrangements. So in the Cayman Islands, we have one system that can be used called a scheme of arrangement, but it's very specific and it requires 75% of approval. And it also actually has to be approved by the court, and that's not just sort of a rubber stamp. The court actually has to look at it and see if it's still protective of the minority shareholders. And I think one of the things that's different in the Cayman Islands as well is that we can't change the creditor's rights at all. It remains the same. I think in the United States you may have a little bit more flexibility in that respect.
Well, I think in the United States, the creditor's rights mostly derives from state law, but because bankruptcy is a matter of federal law, the federal law can trump the state law in certain circumstances and areas that it addresses. How much discretion does the debtor have in a scheme of arrangement to create creditor classes, or is it just limited to just creating an unsecured class or whatever class of creditors that will vote on the plan?
There is some flexibility in it. I mean, so there is some broad powers. There's even a power if you have multiple companies that you can even have a system where you're combining debts and putting things together into sort of a reorganization structure. But again, it is very specific in the sense that you have to get this approval of 75%. And if you're not able to get that, then you're not going to be able to succeed with it.
In bankruptcy, as soon as the debtor files chapter, one of the chapters in bankruptcy, and this is a voluntary petition, the automatic stay comes into effect, and that's a pretty broad stay and injunction. Is it the same in the Cayman Islands?
So you bring up a really good point, because I mentioned voluntary and involuntary liquidations. There's also what's called a provisional liquidation. So often what will happen if there's a scheme of arrangement, because you don't automatically get the stay. So what they do is they'll file a provisional liquidation, which is essentially a liquidation is created pending the hearing of the actual petition. And what that does is it brings down the walls and essentially puts the stay in place. So you have a stay with a provisional liquidation, also with an involuntary liquidation. But when you just file out for voluntary liquidation, you wouldn't have that stay unless it becomes court supervised, and then you have the stay. So let's break that down for a second. So let's talk about parent companies and other affiliated companies. Generally speaking, they're not going to be held responsible for another party's debts. Unless you have like a contractual arrangement or some sort of guarantee or something in place, then obviously those contracts would still be in place. Where you could see something happen is if there was an abuse of the separate corporate personality. So in circumstances where you can essentially pierce the corporate veil, that's when you might be seeing something, but not generally. It's a similar situation with respect to directors and officers of the company. Generally speaking, they're not liable for the debts of the company. However, having said that, directors have fiduciary duties and a duty of good faith to the company. So if those have been breached, they may be asked to contribute to the assets. Also, if the director was knowingly trading while insolvent, there could be civil claims that could arise with that. And there's one other specific thing that's kind of interesting about the Cayman Islands. I don't know if it's different in the United States, so you'll tell me, but we have a specific provision in our law that if the company was trading with a view to defraud its creditors or for some other fraudulent purpose, then any party, including, it doesn't have to just be, it's not included just directors and officers, but any party who was knowingly party to that and participated in the management of the business to that end could be asked to contribute to the assets of the company. So it's kind of this sort of catch-all to get sort of any kind of fraudulent activity. I don't know if you have anything like that or how.
Well, it's actually substantially similar. And again, it's important to break it down to first talking about shareholders or parent companies. With respect to the general rule is no, parent companies and shareholders won't be held liable for the debtor's debts, but there are exceptions, of course, and one of them that you alluded to is piercing the corporate veil. There's also an alter ego theory, and in both of those cases, it's really if the corporate debtor is not maintaining its formalities or it's basically a sham, and one the same with the controlling shareholder or assets are being siphoned off, then the court won't recognize and will reject the corporate form. And with respect to officers and directors, again, it's the same, provided that the directors are maintaining their fiduciary duties, their duty of care and duty of loyalty. They're not going to be held liable. In recent years in the United States, there's been some efforts, some theories such as zone of insolvency or deepening insolvency, in which directors are allegedly more at risk of being held responsible for what the corporation does, either near insolvency and having a fiduciary duty to creditors. And courts are in different places on that. This is usually a function of state law, and so it's important to understand your jurisdiction and get the appropriate professionals licensed in the jurisdiction to help advise on that subject.
Yeah, it's interesting actually, because in the Cayman Islands we have some case law that just on that point specifically, that when you get into this insolvency situation, the directors now, their duties do shift to the creditors. They need to make sure that they adhere to those duties.
Right. It's the same in the United States. I think you can say once the debtor has reached the point of insolvency. Then the creditors are taken into account with respect to the fiduciary duties. But of course, the issue is, at what point, when did the debtor become insolvent? And that can be a very fact-intensive issue.
Right.
Right. So the subject is about voidable transfers for transactions that occurred prior to the bankruptcy case. And we're basically talking about two types of transfers. One is what's known as a preferential transfer, and those are payments made by the debtor to or for the benefit of the creditor on account of a pre-existing debt during the 90 days that precedes the bankruptcy filing. And that is really sort of a strict liability type of legal theory. It's very easy for a bankruptcy trustee or other estate representative to establish that kind of prima facie case. And so usually the litigation surrounds some sort of affirmative defense against the preferential claim, such as whether the claim was a contemporaneous exchange of value, or whether it was made in the ordinary course of business or on ordinary business terms. The second type of voidable transfer is a fraudulent conveyance, and there's two types. One is the intentional fraudulent transfer, in which the debtor will transfer assets with the intent to hinder, delay, or defraud creditors. And this is a theory that goes all the way back to Queen Elizabeth I, and so there's been a lot of law and precedent that has been set over the years with respect to that. The second type of fraudulent transfer is known as a constructive fraudulent transfer, and that you don't have to establish any sort of intent. It's basically asked whether the transfer is made while the debtor was insolvent, or was the debtor rendered insolvent as a result of it, and whether reasonably equivalent value was given in exchange for the transfer. And as to who can bring these claims, it's essentially the bankruptcy trustee. But of course, in a Chapter 11, we have the debtor in possession acting in the capacity of the bankruptcy trustee. In some cases, in some reorganizations, the reorganization plan will set up a litigation trust, in which we'll have a litigation trustee or other estate representative basically taking on these claims and pursuing them post-reorganization.
Okay. Yeah, so I mean, it's pretty similar in the Cayman Islands. The first thing is that once a petition is filed, any transfer will be void unless it's been approved by the court. And then if you're looking sort of before the commencement of the liquidation proceedings, if you can go back up to 6 months, if you have a voidable preference. So that happens is if you have, if the company's no longer able to pay its debts and it prefers one creditor over the others, then that can be a voidable transaction by the liquidator. And then we have transactions at an undervalue. So if you have an asset that's sold for less than its true value, or transferred away, and that is acted to try to defeat the obligations to another creditor, and there's been a creditor prejudiced, well then either the liquidator or in fact the creditor themselves under the statute of frauds can bring a claim to set aside that transaction. So I think it's pretty similar to what you have in the United States.
So while there's an insolvency proceeding pending, like a liquidation, and can creditors basically pursue avoidance remedies while you have the liquidation in place, or do they have to stand still?
Yeah, so so what will happen, generally speaking, is you have to differentiate first between secured creditors and just unsecured creditors. So a secured creditor is going to be able to proceed on their asset that they're secured against regardless of what's happening. But unsecured creditors, once you have a liquidation proceeding in place, you don't get the automatic stay until the order's been made, but there's provision for the court to actually put a stay in place earlier. So in an instance where it looks like it's going to be insolvent liquidation, the petition's been filed, it's very likely that there will be a stay that will be put in place by the court in order to stop creditors from trying to sort of steal a march.
Right. And that ensures some sort of equitable distribution.
Yeah, absolutely. Very passive,
yeah, exactly.
Yes, so the short answer to that is there's nothing precluding financing being obtained by the liquidator when we're in a liquidation. That can be done by security on an asset or any kind of borrowing. The one caveat to that is you need to have the approval of the court for it. It's also not common if there's not assets available in the estate for the liquidator to be able to realize against. that you can have creditor financing or actually even litigation financing, which I think is growing in popularity.
Yes, yes, it is. Is it common to have post-insolvency lending going on, or is that more the exception rather than the rule?
Well, I think it depends on what the situation is, sort of a factual dependent scenario, right? I mean, in my personal experience, you don't see a lot of it. Either there's assets that can be realized again to fund the estate or they're not. They don't normally go into a borrowing situation. So what you see more often is either creditors providing financing where there are no assets available, or the litigation financing if that's available.
Right.
Yeah.
Well, it's similar in the United States. We have a bankruptcy code provision that allows the debtor to obtain post-petition or post-bankruptcy financing, and the law allows the lender to obtain either a lien or a charge that's either equal to the other liens or charges or superior to, and that's supposed to designed to incentivize lenders to provide relief for the debtors post-bankruptcy. When this was first introduced in 1978, this provision allowing for post-petition lending, I think there were a lot of banks and financial institutions that thought that this would be a profitable path, and experience showed that it wasn't. And so I think nowadays we see basically the pre-bankruptcy secured creditor providing the post-petition lending in order to shore up a bad situation rather than new lenders jumping in.
Okay. Yeah, it's interesting.
How much, a lot of times with respect to these post-petition loans, or what we call DIP loans for debtor in possession, it usually ends up being the unsecured creditors committee that ends up negotiating the terms with the lender at some point, because they're more likely to have a little added leverage than the debtor does in that situation. Is that common in the Cayman Islands?
The one big difference is you don't really have the same kind of debtor in possession kind of concept to begin with, right? So remember that we're going to have a liquidator that's going to be in place that's going to be doing this. So the liquidators on it will have a creditors committee, but that creditors committee is going to be approving what the liquidator does, essentially. So in Cayman, it would be the liquidator to be going out and negotiating these things, and then normally having it approved by the creditors committee, the liquidation committee we refer to it as, and then having it approved by the court. So you don't see the creditors having that sort of direct impact.
Right.
Right. So in the Cayman Islands, we have, I think the vast majority of the world's hedge funds are formed in the Cayman Islands. And one of the common structures there is you'll have the master fund will be incorporated in the Cayman Islands, and a Cayman Islands corporation. And then you'll have offshore feeders, and often it's Delaware or other places like that onshore. And so what will happen is that it'd be useful, and also I should say that a lot of the funds end up being invested in the United States, and that's where the investment managers are, and the fund administrator, and all of these things. Right. So what's commonly the case is you'll have the insolvency will start in the Cayman Islands, and we'll put the master fund into official liquidation. And then there's a need to come into the United States. And sometimes you're trying to protect yourself from creditors trying to take a run at the assets in the United States. So now we're looking at something which I don't think we talked about yet, which is a Chapter 15 application. So this is the one I'd give you a call and say, this is what's happening. We need to get in there and make that application.
Yeah, and that's exactly right. And there have been cases out there in which involving hedge funds in which that's actually occurred. And what happens is the foreign representative from the Cayman proceeding comes into court and asks the U.S. bankruptcy court for recognition of the Cayman proceeding. And there's various tests to that, such as whether the Cayman proceeding is part of the debtor's center of main interests, and various tests. And all that is based on the model law of cross-border insolvency that was developed by one of the United Nations organizations. Has the Cayman Islands adopted the model law?
Well, sort of. I mean, so it's pieces of it are there, but I think the main thing about it is the Cayman Islands retains the discretion. They look to see whether it's appropriate in the circumstances to recognize the foreign liquidation. And generally speaking, it normally is if there's assets in the Cayman Islands, there's some other reason for it to be, but it remains at the discretion of the court. So the answer is we haven't implemented it to the letter, and there certainly are some differences, but generally speaking, we're going to respect comity and we're going to recognize foreign proceedings.
Right. So I see through these cross-border cases, much opportunity for collaboration between our two firms.
I think absolutely. Yeah. If you have any questions about anything we talked about, or if you have any other concerns in the Cayman Islands, we're able to assist. My firm's Broadhurst LLC. We have a website, www.broadhurstllc.com. Other issues that might involve the Cayman Islands could be if you're a creditor or a shareholder in a company, or if you're looking to enforce a judgment. My firm does all of that, plus real estate and more. So if there's anything I can assist you with, please let me know.
If you have any questions, or you are a shareholder or a creditor trying to realize assets in the United States, or even a foreign representative who's looking to have a foreign proceeding recognized in the United States, please feel free to consult with us. We'd be happy to talk with you. The name of the law firm is Caplin Drysdale Chartered, and our website is capdale.com, which is C-A-P as in Paul, D as in David, ALE.com.